My apologies, Jesse. Thank you. I think I get it now. Are we back on? Let me know if we're clear on the audio. Oh, Lord. Okay. Thanks so much, Jesse. Appreciate it. Let me get back to the beginning here. Welcome to Fraudulent Conveyances and Transfers. Diminution of debtor to the detriment of creditor from American Jurisprudence. We're going to be going over part 2 here. And of course, we will have Black's Law Dictionary, 9th edition at our side to make sure we leave no word behind. Before we go any further, I want to remind everyone that this is going to be strictly for educational entertainment purposes only, not be used for any kind of professional, legal, lawful, financial, personal, or otherwise uses, just for your entertainment, educational, broadcast purposes, and informational only. Don't do this at home. All right, let's continue here. Let me zoom this in for everyone again, and we'll start back where we left off without audio. All right, all looks good here. Let's continue. We're starting with section 147 of American Jurisprudence, 2nd edition, November 2022 update, and starting with the general section here, section 147 generally. All right, so generally, indeed, please hit the like. Nice seal there, Audit Them. I like the feather pen. Generally, an action to have a fraudulent conveyance of real estate set aside is a local one that should be tried in the county where the land is located, usually pursuant to statutes that provide that actions for the recovery of land or to determine an interest therein must be brought in the county where the land is located. Let's break this down. Generally, an action, meaning this is our suit, to have a fraudulent conveyance of real estate set aside. So now we're talking here in commercial terms already. It's a local one that should be tried in the county where the land is located. So here we're discussing territorial jurisdiction for the action, usually pursuant to statutes that provide that actions, so the actions from the court for the recovery of land or to determine an interest therein. So interest of the land or recovery of the land from the fraudulent conveyance must be brought in the county where the land is located. Now, where the land is subject to the fraudulent conveyance lies in more than one county, the conveyance action may properly be brought in either of the counties, at least where the separate conveyances are made as part of a single fraudulent design. However, some courts appear to regard a fraudulent conveyance as a transitory and hence properly brought in the county of the defendant's residence rather than that where the land is located. So now we're looking at county of the defendant's residence for territorial jurisdiction rather than where the land is located. Because remember, we're talking about real estate here. And as a commercial transaction involving land or immovable property, in other courts, the action may be brought either in the county where the land is located or in the county of residence of one of the material defendants. So let's break this down. The good thing about American jurisprudence is it gives us these nice observations that help us really break down what we just read. The trial court in the county in which the property is located has jurisdiction to hear a judgment creditor's fraudulent conveyance action, even when the underlying judgment has been issued by a separate trial court in another county. However, jurisdiction in a suit to set aside conveyances as fraudulent, based upon an attachment against the land conveyed, is lost when the attachment lien is lost. So again, we're looking at the liens to the property, the conveyances, and previous judgments. All right. If the property is intangible, there is no jurisdiction in equity, because now intangible, we're talking about title, right? Except in the state wherein one of the parties resides. Back to the residence, resides. Where jurisdiction over the person is obtained. Now we're talking about personal jurisdiction here. However, it is no objection that the defendant is a non-resident. So if the defendant's a non-resident, it's not an objection to the jurisdiction over the person. So this is getting to be rather intricate here, but as you can see, it would apply in many cases where there are these typical complexities involving property transactions. All right, so from here we can continue and read some of these footnotes. Okay, these are just case holdings. 1928, so they're rather old, except for this 2003. All right, 1890, nice. Wilson versus Martin Wilson Automatic Fire Alarm Company. All right, now we're on to section 148, out-of-state property or non-resident owner. Now, we might have to go over it and get full definitions from Blacks according to things like resident, but I believe we'll get into that in detail within the context here of this text. While in the courts of one state have no jurisdiction to set aside, by a decree operating in rem, an alleged fraudulent conveyance of lands that are situated in another state generally, if a debtor is failing financial circumstances, makes fraudulent conveyances of his or her real estate for the purpose of hindering and delaying his or her creditors. The latter may maintain a bill in equity in any jurisdiction where the debtor and fraudulent vendee may be found, since in such cases the court does not act upon the lands or make any order in reference to them, but simply declares a certain transaction to be in fraud of creditors. You get this here. So let's break this down a little bit. While the courts have no jurisdiction to set aside of operating in rem, by a decree operating in rem of the property, right, an alleged fraudulent conveyance of lands that are situated in another state generally, if a debtor in failing financial circumstances makes fraudulent conveyances. So this is just the purpose of it here, right, delaying or hindering the creditors. The creditors, right, may maintain a bill in equity in any jurisdiction where the debtor and fraudulent vendee may be found. So we get two different jurisdictions here, or more, since in such cases the court does not act upon the lands or make any order in reference to them, but simply declares a certain transaction to be in fraud of creditors. Pay close attention to this, and we're going to get to this holding here because we're not talking about the physical land itself, but the actual transaction being fraudulent, which would involve other elements. Let's continue here before I get ahead of myself. Again here, where the land that is situated within the state that has been transferred to a non-resident jurisdiction to set the conveyance aside may be acquired by the constructive service of a summons on the non-resident owner. All right. Hey, we got Captain Jack here. Welcome. All aboard. And Press with Rancor. Great to see you here. Glad y'all are here. We're getting into some deep stuff here. That's going to be very enlightening, I hope, for everyone. And this is actually part 2 of fraudulent conveyances and transfers. And we're going to be looking at some real serious impact here of where the rubber meets the road. Let's continue. So let's get in here to the cumulative supplement. Here's one of the beautiful things that I love about American jurisprudence are these cumulative supplements here, because we have some cases here. Louisiana defendants' contacts with Texas were not so continuous and systematic. Pay attention, continuous and systematic, as to render her essentially at home in Texas, as required to establish general jurisdiction over her, in action brought by title company under Texas Uniform Fraudulent Transfers Act, the UFTA, right, arising out of Texas vendors' alleged fraudulent transfer of proceeds from the sale of her home in Texas that was subject to federal lien. Oh, wow. Defendant had never resided in state and had visited state only twice in past 10 years. All of her contacts arose out of her close relationship with vendor, which in themselves were insufficient to confer jurisdiction. Nice. But there's a lot of simple elements in here to pay attention to. Again, the continuous systematic contacts. A good takeaway here. Never resided in the state. Never resided. Had visited only twice in the past 10 years. And her contacts rose out of a close relationship. All right. Let's continue here. Let's see. Case holdings again. 83. This one we are looking at was, let's see here. It's right here. 2018. So this is quite current. 64, 42, 49, yeah, 35. Common law. Let's continue here. Fraudulent conveyances and transfers, section 149, where other relief is also requested. Where an action to have a fraudulent conveyance set aside is joined with a claim for other relief that ordinarily requires trial in a county other than that where the land is located. The action is properly brought in such other county. However, some courts have determined that the location of the land is controlling at least where the relief as to the fraudulent conveyance is not purely incidental. Location of the land is controlling at least where the relief as to the fraudulent conveyance is not purely incidental. Interesting here, and I guess these are quite old case holdings too. Let's move along here to the amount in controversy for jurisdictional purposes. Okay, so generally the amount in controversy for jurisdictional purposes in a creditor's suit to avoid a conveyance as a fraud upon creditors is the amount of the plaintiff's claim. Okay? There is also authority broadly to the effect that the judgment in a suit by a judgment creditor for reliefs against property of the debtor and the value of the property must each be not less than the required jurisdictional amount. All right, so we get that. Courts aren't going to waste their time with penny cases here. Separate or successive proceedings. Although a creditor who seeks to set aside a fraudulent conveyance by his or her debtor may not pursue the same property in repeated proceedings, such creditor may, by successive proceedings, have different items of property made subject to his or her judgment. Thus, equity may, by successive actions, subject to the payment of a judgment property in different counties fraudulently conveyed by the judgment debtor. Interesting here, and that's that's footnote 2 from 1937, and again we have this Rice versus Indiana Department of Environmental Management, 2003. And we're moving along. We're getting to the good stuff here. Let's stick with it. Okay, here we go. On to section 152, generally. All right. Pay attention here. One whose right to enforce a claim has become barred by the statute of limitations loses his or her status as a creditor and may not maintain a proceeding to set aside a transfer of property by his or her debtor upon the ground that it constitutes a fraudulent conveyance. All right. Yeah, all this text is good stuff. That's for sure, Captain Jack. All right, let's break this down. They love to. Here's what American jurisprudence likes to do. They like to front load you with the heavy, dense information right from the start, but then they slowly break it down into digestible chunks until you get the little bits and pieces that you can actually implement into action. And that's one of the beauties of the way they've constructed this text. So let's start again with the heavy stuff. Let's at least break this down so we'll be all nice and juicy for the rest of it here. One whose right to enforce a claim, so the one to bring the action, right, has become barred. Okay, one whose right to enforce a claim has become barred by the statute of limitations, right, loses his or her status as a creditor. So statute of limitations, it loses her status as a creditor and may not maintain a proceeding to set aside a transfer of property by his or her debtor upon the grounds that it constitutes a fraudulent conveyance. So there's a statute of limitations where they lose their status as a creditor all along. Likewise, one who has the status of a creditor may lose his or her right to have the transfer or conveyance set aside by the running of the statute of limitations or by laches or delay in instituting it. The protection of the statute may be invoked by the transferee or grantee, with the result that if the transferor's creditors have not, within the statutory period, brought suit to have the conveyance set aside, the title of the transferee becomes immune to the attack by them. Whether the proceeding is a suit in equity or an action at law. Nice. Let's digest this one more time. This is interesting here. The protection of the statute of limitations may be invoked by the transferee or grantee, with the result that if the transferor's creditors have not, within the statutory period, brought suit to have the conveyance set aside, the title of the transferee becomes immune to attack by them. Nice. Whether the proceeding is a suit in equity or an action at law. Furthermore, where suit has been brought for the benefit of the complainant alone, there is no statutory prohibition against the bringing of similar suits by other creditors. Other creditors may not, by intervening after the running of the statutory period, claim advantage of the filing of the action and the tolling of the statute as to their claims thereby. So, again, we're covering all the grounds here. To help us digest it, we get the observation, which is another beauty of American jurisprudence. Here we go. Observation. The statute of limitations does not have the effect of converting a fraudulent deed into a valid deed by reason of the lapse of the prescribed time. Instead, it simply forbids the right of action for relief on the ground of fraud. Hence, if the question as to the fraudulent character of the deed arises in any way other than in such an action, there is nothing in the statute that forbids it being assailed for fraud. So you're not absolving it from fraud, it's just that particular transfer after the statute of limitations runs out. That won't be attacked, but if the deed itself is in fraud, that's a whole different issue. Thus, one who has made out a prima facie case for the recovery of land is not prevented from attacking as fraudulent a deed that is set up in defense because the time for bringing an action to set aside the conveyance as fraudulent has expired. There we go. So that's an important observation to be aware of. Prima facie case for recovery of land is not prevented from attack as a fraudulent deed that is set up in defense only because the time for bringing action to set aside conveyance as fraudulent has expired. So that in and of itself may not be enough. It's not preventing an attack, let's just say. Okay. When a creditor fails to secure his or her judgment within the statutory period from the time he or she has knowledge or notice of fraudulent conveyance by the debtor, the creditor will ordinarily be denied by laches to the right to set aside the conveyance. However, the question as to laches involves factors other than the delay in the assertion of the complainant's claim. The court properly takes into consideration the facts that during the period of delay, the value of the disputed property has increased, that parties to the conveyance and witnesses have died, and that no person at that time interested in the property is implicated in the fraud as the ground of relief. Wow. On the other hand, it has been found that a delay of as much as 6 or 7 years from the date of the allegedly fraudulent conveyance does not constitute laches where there is no showing that the defendant has been prejudiced by such delay. Okay, let's look up the word laches here just because I think that's something that needs a little bit more clarification from Blacks. So let's get right down to it. And as I said, it's a scan copy. It doesn't like searching, so we're going to have to look manually through it, which doesn't go all that fast, but just bear with me so that we make sure we leave no word behind. And if anyone's in here and hasn't hit the like already, please hit the like to let other people know that this information's out there and they can throw in some questions or comments along the way as we go through this text. All right, I think it's caught up with my scroll bar here, but not quite. Come on, there we go. It's always nice having a hard copy of this by your side because it's always nice when you flip through it, you come across other words that will, you get a little bit of a digression, yet it's always beneficial. And I pass right by it. Come on, get back there. It's not too responsive here. Just bear with me, please. All right, there we go. Ah, geez. All right. Come on, I was on L. Oh, here we go. Okay, here we go. Laches. From French, remissness, slackness. 14th century, laches. Unreasonable delay in pursuing a right or claim, almost always an equitable one, in a way that prejudices the party against whom relief is sought, also termed sleeping on rights. So this is equity. So this is an interesting word here. Let's dig a little bit deeper here. Early in its history, Chancery, this is our courts of equity predecessor, developed the doctrine that where the plaintiff in equity delayed beyond the period of the statute applicable at law, relief would be refused on the ground of laches, even though no specific prejudice to the defendant was shown. Today, in most states, there are statutes of limitations applying to suits in equity. Despite these, however, the doctrine still holds that even if delay is for a shorter period of time than that of the statute, it may still bar equitable relief if it is unreasonable and prejudicial to the defendant. Interesting. So, because of this, this concept here of latches, it may not even require the entire statute of limitations to bring an action. So let's see if there's anything else here. And that's Remedies in a Nutshell, 1985. That sounds like a good book. John F. O'Connell. We'll have to look that one up. The equitable doctrine by which a court denies relief to a claimant who has unreasonably delayed in asserting the claim, when that delay has prejudiced the party against whom relief is sought. Limitation, right? The doctrine of latches. In an instance of the exercise of the reserved power of equity to withhold relief otherwise regularly given, where in the particular case the granting of such relief would be unfair or unjust. And that's from a treatise on equity, 1930. So we have estoppel by latches. Interesting there. So estoppel by latches, another interesting one for future reference and extra credit. So let's continue back to the text here. Oh, it's going to do that every time, huh? Let me fix something really quick here because that's going to be annoying. Can't have that refresh every time I switch back. There we go. All right, one more time. We got to zoom back in and figure out where we left off. All right, so give me a hard time here. Give me a second. All right. Separate successive pleadings. We saw that one. More time here. Wow, it's really messed me up now. Give me one more second here. See why it's not doing this. Okay, let's refresh a cache. Let's just do that. Okay. All right, one last time. Let's get right to where we left off. I'll edit this out of the final video. All right, here's where we left off. So, one whose right is become barred loses the status as creditor. Okay, here we go. Likewise, one who has the status of a creditor may lose his or her right to have the transfer or conveyance set aside by the running of the statute limitations or by latches or delay in instituting suit. So now we know. All right, the protection of the statute may be invoked by the transferee or grantee, with the result that the transferor's creditors have not, within the statutory period, brought suit to the conveyance set aside. The title of the transferee becomes immune to attack by them, right? What else? We have the latches here. Okay, if the suit has commenced within the statutory period, so within the statutory period, the complainant will not ordinarily be denied relief on the grounds of latches, because latches usually be less than the statutory time, meaning that the delay, you wouldn't have it longer than the statutory time and still be claiming delay because you've gone past even the statutory. You're not saying that like the statutory time wasn't enough delay to cause an issue. So I can see why it's not ordinarily. Okay, so in addition, there is authority that the defenses of latches and limitation may not be successfully invoked as long as a creditor's right of action upon the debts remains enforceable against such defenses. So interesting here, and that's 15. We'll look at that. In some states, there is no statute of limitations on actions to avoid a transfer as having been made with the actual intent to hinder, delay, or defraud creditors. Rather, the bringing of such an action is limited only by the doctrine of latches, which we just read. Cumulative supplements. Cases 1 year statute of limitations period in the Uniform Fraudulent Transfers Act. Remember, we spoke about this on the last episode, part 1. Applied to the creditor's post-judgment supplemental complaint against a debtor's former wife as impleaded third-party defendant to set aside purported fraudulent transfers of real property rather than limitation period governing proceedings supplementary, since rule regulating proceedings supplementary specifically incorporate provisions of the UFTA and its applicable rules of civil procedure in connection with claims concerning judgment debtors' assets brought under UFTA. Nice. So this is, oh gosh, yeah, Fleming 2020. All right, so let's look at this. We're going to reread it. The remand was required in action in which judgment creditors sought to set aside transfer by judgment debtor under UFTA for a determination of whether claim was time barred, whether records suggested that efforts were made to conceal some or all of the transfers from creditor, and trial court had not considered the issue in the first instance in granting summary judgment to the judgment debtor. This is 2016 here. So two interesting cases here, both involving the UFTA, the Uniform Fraudulent Transfer Act. Again, 1 year statute of limitations period in the UFTA applied to the creditor's post-judgment supplemental complaint against the debtor's former wife. Boy, they're really going for it here. As impleaded third-party defendant to set aside purported fraudulent transfers of real property rather than limitation, governing proceedings supplementary, since rule regulating proceedings supplementary specifically incorporated provisions and its applicable rules of civil procedures in connection with claims concerning the judgment debtor's assets brought under the UFTA. So I guess the UFTA was superseding all this. I'm going to look into this case some more, and this is very current, 2020, and here in the great state Florida. Here we go, another one here. This is in Maine. State was bound by statute of repose governing claim for fraudulent transfer under Uniform Fraudulent Transfer Act, even if state was not expressly named in the UFTA. Statute used term claimant, and although claimant was not defined, creditor was defined as a person who has a claim, and person was defined to include government or governmental subdivision or agency. Yeah, get that? Person was defined to include government. Wait a second. So person was defined to include government or governmental subdivision or governmental agency. Nice. Well, that's awfully convenient. And that was Maine 2019. Interesting. Let's see what else we got here. These are all just holdings. Some quite old. And we get the limitation period under the UFTA. And some of the nice forms they have here, the pleading and practice forms, fraudulent conveyances, answers, defense, failure to bring an action within statutory period after date of fraudulent transfer under UFTA. Nice. So the UFTA provides that a claim for relief or a cause of action with respect to a fraudulent transfer obligation is extinguished unless the action is brought, 1, within 4 years after the transfer is made or the obligation was incurred, or, if later, within 1 year after the transfer or obligation was or could reasonably have been discovered by the claimant. There you go. That's a nice caveat. 2, within 4 years after the transfer was made or the obligation was incurred. 3, or within 1 year after the transfer was made or the obligation was incurred, depending on the statutory circumstances and requirements. The Act also provides that, unless otherwise displaced, the principles of law and equity, including the law relating to laches, which we just went over, supplement its provisions. So remember, to supplement is to add to, yeah, I guess that would be adding to it. Comment: statutes of limitations applicable to the avoidance of fraudulent transfers and obligations vary widely from state to state. The periods prescribed apply whether the action under this Act is brought by the creditor defrauded or by a purchaser at a sale on execution levied pursuant to statute, and whether the action is brought against the original transferee or subsequent transferee. The prescription of statutory periods of limitation does not preclude the barring of an avoidance action for laches. So, laches. And there we go, the UFTA Act. That's something that we want to be aware of if we're dealing with any of these kinds of. So we got statute of limitations applicable. Let's get right here to this observation. Is borrowed from the statutes. In the first place, thus, from instance of fraud or conveyance action brought by Chapter 7, debtor attorney's former client, in order to enforce the client's right under a judgment in a legal malpractice action, would be subject, like the underlying malpractice claim itself, to a 3-year statute of limitations, and has to be brought within 3 years of the challenged transfer. 3 years from a Chapter 7, huh? Okay. Good stuff to see here. These observations on American jurisprudence are invaluable. And we have a cumulative supplement. Where a plaintiff, this is the case here, where a plaintiff alleging a possessory interest in land brings an action to clear title or to recover land obtained by a fraudulent conveyance, that action is governed by the 10-year statute of limitations for actions to recover land, rather than the 3-year statute of limitations for fraud. Interesting again. Powerful stuff that you'll learn nowhere else. And I think this is going to be a good place for us to lay off here, because we got Section 155, limitation of time to sue, deceased, transfers, estate, or representative. We're starting to get off into the weeds here. And if there's anything else, I will do a part 3 if there is something else in here that we find that's going to be beneficial to us getting a better understanding of these fraudulent conveyances and how they are affecting a lot of the assets that people use in their pursuit of happiness and their life and their liberty. And it's important to see where this the UFTA, although it is a uniform commerce code type of laws, or we should say, I guess it's a uniform code. It is something that is based upon a lot of common law and equitable principles, and therefore, when those things do fall into the benefit of us, the people, then it behooves us to know how to use them to our benefit, and to get the results and justice that everyone should be getting here, as our country is basically built on the concept of justice for all. So on that, I would like to thank everyone for spending the time to come and learn about this very important issue of fraudulent conveyances and transfers. American jurisprudence is always a great reference to learn about these things and expand our knowledge further into actual practice of law whenever we see fit, or just for general education purposes. Again, this is strictly just for educational entertainment purposes and for your informational enjoyment. I want to thank you all for coming again, and I hope to see you all on the next stream. Peace out.